All right, everyone, we start off today with some rather big Second Amendment news. This is another shot across the bow of the anti-gunners, actually, in the wake of the Bruen decision. Again, people not giving Trump credit for incepting a Supreme Court incarnation that made such a major decision. If you happen to support the actual meaning of the Second Amendment, you should be fucking kissing his feet, at least for that one purpose. Link in the description, archived of course. ERPO, the red flag law in the state of New York, has been ruled unconstitutional. This leaves doubt as to whether there's really any way they can incept a red flag law there. The standard typically is this, and it's not just New York that uses this particular metric. The metric is that a person can have their weapons stolen from them if someone in proximity to them, so a neighbor, a friend, relative or something, feels that they might do something illegal or stupid with those weapons, and a court can then issue a warrant for the removal of those weapons. No crime has been committed. There's no institutionalization, etc., etc. In some cases, the person has great difficulty getting the decision reversed because, of course, the decision is being legally made against them without their foreknowledge, so there's no way for them to prepare a defense. The idea is, well, we think that you're such a risk that if we tell you that we're intending to do this, you're going to pop off, so for pragmatic reasons, we're not going to allow you to be armed. The problem, there are several problems. The pragmatism argument kind of falls flat when you look at the reasonings behind some of these confiscations of weapons. The constitutional argument clearly falls apart. And the reason that it falls apart is due to Bruen. In fact, if you look at the language, again, link in the description, archived of course, of this decision, right at the end, it sums it up in black and white. The Second Amendment can't be reframed as a subordinate right, as being lesser than the rest of the Constitution. So, for example, you can't make the pragmatic argument of public safety outweighing the Constitution. You couldn't say, for example, a person should be banned off of Facebook because we feel that they might incite a riot. Well, you wouldn't be able to do that. The tech firm can be coerced, apparently, into doing things like that. We've seen that with the Twitter files and other leaks and releases recently. But the government can't, a court order can't be put into place banning you from speaking on the internet because you might say something that promotes terrorism. You might lead to rioting. You might yell, "Fire in a crowded theater," which, by the way, is an old and dated constitutional argument that never really passed muster anyway. You couldn't say, well, we think that this person is, imagine the Fourth Amendment. We think that this person is going to deal drugs. We know that they grow weed plant. We've left him alone on that, but we have a feeling that he's got some coke and he's going to deal it to school kids. So we're not going to respect his right to privacy and get a court, an actual warrant to search the premises upon a reasonable suspicion that there is a crime in progress or has happened that we'll find evidence for. We're just saying we have a hunch. So there is no evidence threshold. That's effectively the way red flag laws work. These have been promoted even by some very good politicians. Donald Trump has alluded to them. Ron DeSantis, of course, is in support of them. But they're unlawful. The idea is that it's pre-crime. Upon scrutiny, they will fall by the wayside the same way that every other meaningful restriction on firearm ownership, accessories, etc. Should, because the Bruen decision makes it clear that it is not a lesser or secondary right. It has to be upheld as much as any other amendment. The right to a speedy, fair public trial. Well, sometimes that's ignored. We've seen that recently as well. But typically speaking, if there's any malpractice, any malfeasance with regards to your right to put on a defense, be assumed innocent until proven guilty, well, it can result in a mistrial. Retroactively, sometimes people are exonerated because of this. You can't simply shut down someone's ability to speak because you think that they might say something that's off the wall. You have to wait until they actually say something that would be legally actionable to take any form of counteraction whatsoever. The fact that you say, well, in this case it's different because guns can kill people. You could make the same argument literally for the other amendments. You could say this person is too dangerous. We know that he's guilty. So fuck the right to a fair trial. We need to make sure, he doesn't have the right to make bail. He doesn't have the right to put on a defense from outside of the bars because he might haul off and do something terrible. Well, this state is not functioning properly. It's not in the interest of the people of this state that its 10th Amendment rights be upheld. So we're going to strip that state of its ability to govern and govern by proxy because the people there, we conceive of them as suffering, or we think that the state might do something atrocious. This person can't speak because they will say something in praise of ISIS. That person has no reasonable right to privacy because their neighbor says that they smelled crack being cooked. Well, again, you're going to need something a little bit more beefy than that, and there's actually a process to go through before you raid the person. In fact, the whole no-knock raid system for any crime shouldn't exist when you really think about it, unless there's actual evidence. If there's evidence, okay. Sometimes that's respected in the United States. It should be respected more. Quartering soldiers in people's homes. That's a banned in the Constitution. You can't take a person's property and say, okay, you have to bed these soldiers here because, we're marching around, we need somewhere to put them. You could make a pragmatist argument and say, yeah, but this particular county is in uproar and there's nowhere else for the troops to go, so, they really need a bed, so, fuck you, basically. I'm sorry, but we're quasi-eminent domaining your townhome for a limited period of time to put this squad of men in it. Well, that would be unconstitutional. The pragmatist argument means nothing. What Bruen has done, more than anything else, and you've already had the erosion of some gun control in the United States for the last couple of decades anyway, especially with regards to carrying weapons. Fully half the states now have constitutional carry. A couple of decades ago, it was one state, and that's the state of Vermont, ironically enough, which is run by the far left. They are seeking to denigrate the Vermont state constitution's explicit protection of the right to bear arms, even beyond the Second Amendment of the U.S. Constitution. They're not having a very good time of trying it. Of course, all of Vermont's gun control laws technically violate its own constitution as well as the U.S. Constitution. For some reason, I haven't seen as many legal challenges of these things. Basically, the only upholding of gun control that's been queried post-Bruen has been the mag restrictions in Rhode Island. I can't think off the top of my head of any other court that's actually decided to ignore the Bruen decision, which a lot of people were worried about. Well, the courts will just ignore it. They won't take up the cases, etc. They'll find a weaselly way around upholding the right to bear arms. So far, so good, actually. If they can do it in New York, you'd think that they could do it in a more sane state, by the way. This isn't coming from some outside judicial entity. This is coming from the state of New York's own judicial system. The writing is on the wall. Red flag laws, mag restrictions, attachment restrictions, keeping non-violent felons disarmed. All of these things need to be scooted into the dustbin of history because they're basically, they're very nouveau under U.S. law. First 100 years, you have no gun control of any kind. Subsequently, it isn't really until the 70s that you start getting most of the modern wave. Half of it's already deteriorated. A lot of people want to make the crazy argument that gun control is a tradition. And this understanding of the Second Amendment as applying to individuals is a new one. They cite McDonald v. Chicago, D.C. Heller, and say it's a 2000s era thing. No. Prior to Cruikshank in the 1870s, that was always the understanding. For almost the first century of the United States, there was no conceptualization of any form of disarmament, etc. The one exception is if a person is a criminal lunatic. Therefore, violent felons, at least upper-level violent felons, assault is one thing, murder is a different. They would be considered criminal lunatics under the understanding of the 1700s. They can be disarmed. A person who is completely a mental vegetable, clearly, is not part of the militia and is incapable of wielding arms properly, too. A person who is not the age of majority, who cannot vote, cannot be a member of the militia, cannot be called up involuntarily to serve in a militia, I would point out as well. We even have that understanding. And so those individuals, of course, do not yet have their full constitutional rights. Literally everyone else does. Congrats to the state of New York for very confusingly leading the way and ruling your red flag system completely unlawful. The hope is that it goes bye-bye in the entire nation. That's about all. Peace out.